The conversation continues at LarsLarson.com.
Welcome back to the Lars Larson Show. Pleasure to be with you, and I'll get back to your phone calls shortly. If you want to jump in to the best conversation in talk journalism, it's 866-439-5277. Emails go to talk@LarsLarson.com. And a warm welcome to Byron Henry, who's an attorney and partner at Scheef and Stone, which is a law practice in Frisco, Texas. Mr. Henry, thanks for joining us.
It's my pleasure, Lars.
So Ohio has this bill that's apparently already passed both houses of the legislature that would ban abortions once a fetal heartbeat can be detected. I like the idea of a law like that, but it's now been sent to Governor John Kasich, and he hasn't said whether he plans to sign the measure or not. What more can you tell us about that?
Well, first and foremost, obviously, John Kasich has looking back through the records, he's considered a moderate by a lot in the Republican Party and across the country. But if you look at his record on abortion rights, especially in Ohio, he's actually been a friend of the pro-life movement, such that Ohio has some very restrictive, if you want to call them that, or very tough laws on abortion access. There's only 8 clinics remaining. He's come out and said that he's for banning abortion except for the instances of life of the mother, rape, and incest. And most of the bills he's signed have been along those lines. The problem here is he's also a smart person, and we learned this with Oklahoma's law that was passed earlier this year, banning abortion except in specific circumstances, where a very conservative governor, Mary Fallin, did not sign it because she said that she didn't think it would withstand a court challenge. And so that's really what you have going on here with Governor Kasich, not whether he is for a bill like this, whether it's consistent with his ideology, but whether or not it would withstand a court challenge, and is it worth the time and the effort to sign it, only to see it struck down a month or years later.
Well, as an attorney, how would you look at this? Because, tell me if I'm wrong, Roe v. Wade is essentially a case not so much about abortion, or not necessarily about abortion, but about medical privacy, that says a woman has a right to make medical decisions with a doctor. I don't happen to agree with Roe v. Wade, but that's the gist of it. And in this case, if you apply a medical standard, that is, once you can detect a heartbeat, then that's life, and we can't let you kill that baby. That seems like applying a medical standard that doesn't invade anybody's privacy. It's just a medical standard like any of the other standards that we apply to doctors and clinics and hospitals, isn't it?
Well, certainly, and it's not, you're exactly right. The two-pronged part of Roe was one about a person's privacy or a woman's privacy between her and her physician, but it's also about the regulatory structure and the trimester structure, which has basically gone by the wayside in current medicine, but we still have Roe on the books and have to kind of look to it for guidance. And what you have there is basically a system that subsequent court decisions, including the United States Supreme Court, has said that the trimester system means as follows: very few restrictions in the first trimester, reasonable restrictions in the second trimester as long as they're consistent with the government interest, which includes protecting the health of the mother and the viable fetus. And in the third trimester, basically the burden falls on the other side, and you can basically restrict abortion with the state's interest in protecting the fetus in the third trimester, except in extreme circumstances such as life of the mother. So what we have here is a bill that rolls all the way back, gets rid of the trimester structure, and just says once the fetus, not as viable, by the way, which a lot of states have that law, including Ohio, it's saying that once a heartbeat is detected, the procedure is banned, which, you're right, has nothing to do with privacy between the doctor and the physician, but what it does have to do is going basically around the trimester structure and basically banning abortion according to science very early, because we know that a heartbeat can be detected between 6 and 8 weeks into a pregnancy. So this would be the first attempt, I think, and the farthest or the earliest in the pregnancy that a state has attempted to outright ban abortion since we've had, the more recent cases following Roe v. Wade.
Well, I haven't asked you your position on it, but I take it that you're pro-life. But tell me this, if the opponents of this go to the Supreme Court, on what basis will they tell the court, we think this fails the test and is unconstitutional? I mean, how would they argue against something that sets a medical standard in the same way that, for example, and tell me if you think the comparison is appropriate, if somebody is in a hospital bed, they're being assisted in breathing by a respirator, but they're still showing brain activity. We have a pretty hard and fast line that says as long as you're still showing brain activity, the doctor can't come in and unplug you and kill you because he'd be murdering you. But once you have ceased brain activity, if your family says we're ready to say goodbye, then the doctor could unplug you at that point if there's no brain activity. We've drawn a medical line for where life ends and death begins. Is this any less legitimate than that?
Well, it's not less legitimate, but the issue then becomes what the Supreme Court says in Roe, which I know is from 1973, so it's a very old decision and science has moved on, but the Supreme Court has not altered this holding, and that is that in the first trimester, or let's take it out of Roe and just say early in the pregnancy, the state's interest in protecting a fetus as a person or in preserving life of the fetus is at its lowest, meaning then it was in the first 13 weeks, the state basically has no interest in protecting the fetus. That was part of the holding of Roe. And therefore, what you're saying now is the court would say, we still believe that you have to measure it based on a state's interest in protecting a fetus. But what this state is saying is we have an interest as soon as a heartbeat is detected, and you would have to get a court say, I can buy that. I can buy that once a heartbeat is detected, the state's interest in protecting a fetus goes up. It goes up even higher once there's viability, and of course, as you get late in the pregnancy, it's extremely high, such that you could basically ban or prohibit all late-term abortions because the state's interest is at its zenith. So you basically have an issue where you'd have to ask the Supreme Court to say, let's throw out the Roe trimester and let's measure a state's interest in protecting a fetus, an unborn child, at 6 or 8 weeks instead of 13. Which is not that much of a stretch. No, it's not. And Mr. Henry, let me ask you this. You may or may not know this stat. I know, for example, in the state I'm in right now where our broadcast facilities are, state of Oregon, if a murderer kills a pregnant woman, he's only committed one murder. But in California, if a murderer kills a pregnant woman, he has committed 2 murders, and they draw that distinction. So the state of California sees an interest in protecting that unborn child, and I don't even recall whether the state of California sets a limit to say you have to be so many months pregnant before your baby is considered a human being worthy of protection. But are there many states like that already provide protection, say for a pregnant woman, where the state's already asserted its interest in protecting that life? Absolutely, and most court cases say, and Texas is one of them, that so long as you don't trample on the mother's rights under Roe and its progeny, you can protect the life of the fetus to the fullest extent of personhood at a state level. The state can, as long as you don't step outside the lines and affect the woman, the mother's rights vis-a-vis the federal constitution with respect to abortion. So basically you have this huge, if you were looking at a Venn diagram, it would be a huge circle which says the state can do whatever it wants to protect the life of a fetus, except for when it runs over into the constitutional protections for a woman, the mother's right to abort her own unborn child prior to the state interest being enough. And as of Roe, enough usually means first 0 to 15 weeks of pregnancy. The state cannot interfere with a woman's right to abort the fetus. However, that would be the subject of any appeal in this case. It would be, wait a minute, the law's changed. Tons of states protect fetuses from conception, and Roe was at 13 weeks, and science has advanced, and so now we can hear heartbeats. We're going to make it 8 weeks. So, well, I personally hope that John Kasich goes ahead and signs the bill. He knows he's setting it up for a court case, and I hope the Supreme Court gets to take another run at this and maybe bring us into the 21st century from the 1973 decision on Roe. Mr. Henry, I appreciate the time. Thanks so very much. Anytime, Lars.
You bet. Byron Henry, who's with the Scheef and Stone law firm out of Frisco, Texas. Back in a moment. Your calls at 866-439-5277. You've got the Lars Larson Show.